Members, we have a quorum, and this is the appointed time. I call to order the panel on securities meeting. This is a new year. May I wish everybody happy new year and good health, and please return to your designated seats. Item 1 on the agenda, confirmation of minutes of the previous meeting. Minutes of the meeting held on the 4th of December 2018 have been forwarded to members. On the 24th of January 2019, I have not received any proposed amendments. May I take it that the minutes are confirmed? All right. Item 2, information papers issued since the last meeting. Will members please note? Yes? Mr. Adiju. Thank you, Chairman. I see that the administration has responded to a joint email sent by myself and a number of members on a proposed duty visit to Xinjiang. I want to confirm, first of all, whether the Security Bureau does not intend to engage in any discussion with the panel regarding the outcome of the duty visit, and second, whether the administration can arrange for LegCo members to go on a duty visit to Xinjiang on anti-terrorist measures, including the re-education camp, which the Beijing government considers effective. Please reflect this view to them. All right, your comment is noted. Date of the next meeting and items for discussion. For the meeting in March, the administration has proposed to discuss 3 items. That is development of the Correctional Services Department's Smart Prison, and second, Animal Watch Ambassador Program proposed by the government, and also collaboration with the government and other organizations on preventing abuse to animals, and the third item, the new generation of e-passports. All right, I think these items are close to the heart of members. And next item, if you wish to speak, please press the button now. Item 4, cooperation between Hong Kong and other places on judicial assistance in criminal matters. May I invite the administration to come in? We have 19 members waiting to speak. We have quite a heavy agenda today, and I need to ensure that everyone who wishes to speak will have time to speak. So each will be given 4 minutes. If your speaking time limit is up, I will stop you from going further. So, Secretary, welcome to our meeting. I won't go through the attendance list, which will walk us through the paper, Secretary. And I also noticed that usually the speaking time limit will not be observed, but today I need to uphold this rule strictly. So I'll give 2 to 3 minutes for the Secretary to give some concluding remarks after all members have spoken. So over to you. Thank you, Chairman. I'd like to brief members on the current regime on cooperation between Hong Kong and other places on judicial assistance in criminal matters, and also the SFO arrangements, and our legislative amendments proposed. Now, the controversy is a recent murder case in Taiwan. The culprit eventually came back to Hong Kong, and as a result, because of the loophole in our legislation, we could not accede to the request for sending him to Taiwan for trial because of the limitations. So justice is not done because of that, and family members grieved could not be relieved, and the perpetrator could remain in hiding in Hong Kong, endangering the personal safety of the general public in Hong Kong. Now, the limitations are that, first of all, between Hong Kong and Taiwan, there is no long-term agreement or arrangement on SFO. In relation to the mutual legal assistance in criminal matters and surrender of fugitive orders, that is CAP 525 and CAP 503, there is a clear stipulation that there should not be any arrangement between Hong Kong and other places in the mainland. And also, if there is a case for request for surrendering a fugitive, we need to process the case before issuing a provisional arrest warrant by the Legislative Council. Yet, in the electoral scrutiny process, the details will be disclosed, and the fugitive will be aware of the details, and that it is very likely that the fugitive will abscond during the electoral scrutiny period. Not to mention that the scrutiny period usually ranges from 28 days at the earliest or 49 days at the latest. Without any legislative authority, there is no way we can detain this person. Also, because of the details disclosed in the public domain, the discussion may also be challenged in court on the ground that the case details have been divulged and that fair hearing has been compromised. We therefore need to make legislative amendments so that after the chief executive has issued the authority to proceed, the provisional arrest warrant can be issued by the court. Regarding this certificate, there will be an agreement attached showing the validity of the agreement made between the two places, and also the case can be proceeded with under Cap 503 of the laws of Hong Kong, and that is Fugitive Offenders Ordinance, so that the statutory procedures under the ordinance and all the relevant human rights requirements can be proceeded with for a fair hearing of the case. That is, the court will consider whether there is sufficient grounds for the person to be surrendered, and this is set out in section 10(6)(b)(3) of Cap 503, and also for section 5(2) of the ordinance, if the case is committed in Hong Kong and if this constitutes a crime in Hong Kong, this requirement will also be met. And also in Schedule 122B1, it sets out 46 types of offences, including homicide, possession of firearms, and other serious crimes. And according to 5(1)(a), this is not a serious crime, and also for 5(1)(c), this person is not prosecuted or penalized on the grounds of this person's race, religion, nationality. And also, according to the ordinance, this person will not be prejudiced, or that the person's liberty will not be restricted in any way because of the aforementioned reasons. And also the person is not to be transferred to another jurisdiction according to 5(2). The basis of transfer must be that of the offense set out in the agreement, and if the court is not satisfied that the case meets the above requirements, or that the case breaches the relevant provisions in the law, the person may be released, and the requesting party must also indicate that or assure that the offender will not be sentenced to death. And this is set out clearly in section 13(5). For all the safeguards of human rights, they will be maintained, and they will not be amended in this exercise. For example, this person may apply for habeas corpus, and this person also has the right to lodge an appeal and also file a judicial review against the final order issued by the chief executive for his surrender. In relation to the one-off arrangement, we can also impose other safeguards such as time limit, and also when the two jurisdictions have made long-term arrangements, the one-off case-based approach will be scrapped. We have drawn reference to other countries' legislation such as UK, Canada, New Zealand, etc. For these jurisdictions, they also use these arrangements in which certificates may be issued by the executive authorities, such as, for example, in Canada, the certificate will be issued by the Department of Foreign Affairs, which is similar to our arrangement in which the certificate will be issued by the chief executive. Now, this case highlights the difficulty in our enforcement action. Our exercise seeks to plug the legislative loophole. It is not just about the case in Taiwan. We need to plug this loophole because this loophole could very well happen in any other jurisdiction with which Hong Kong has not signed any long-term SFO arrangements. For SFO and MLA in criminal matters, apart from upholding justice, we also need to protect the public of Hong Kong against any safety concern or threat imposed by fugitives hiding in Hong Kong. Must we allow the rapist or murderer be hiding in Hong Kong, thereby endangering the personal safety of the general public in Hong Kong? We must ensure personal safety and public order and uphold justice in combating crimes and tackle any case of fugitives coming from jurisdictions where Hong Kong has not entered into any long-term arrangements on the surrender of fugitives. We'll be happy to take questions from members. I have received 3 motions moved without notice from Mr. Alvin YEUNG, Mr. Dennis Kwok, and Ms. Claudia Mo. I think these 3 motions are related to this discussion item. So in due course, we'll vote on these 3 motions. But if other members would wish to move motions without notice, please submit them to the Secretary as soon as possible. 23 members have indicated they wish to speak. Please observe the time limit, starting with Dr. Cheng Shung Tai. Thank you, Chairman. Well, I understand for the homicide case in Taiwan, it is really causing public outcry in Hong Kong because the crime is acknowledged but not dealt with. But for this legislative exercise, I think you need to explain clearly to the public, because when we talk about the surrender request between Hong Kong and Taiwan, it is now rephrased as Hong Kong and any other place in the mainland. Well, there is no explanation why Taiwan should be dealt with as another place in the mainland. So I think the administration should explain this first. Secretary. Thank you, Chairman. As I explained very clearly, for the proposed legislative amendment, the objective is not only to deal with this homicide case. More importantly, we need to deal with the loophole in our law. At the moment, if there is no long-term agreement with another jurisdiction, there is great difficulty on our part in taking action. And the law expressly provides that the SFO does not apply to another place in the mainland. That means the MLA in criminal matters or the SFO does not apply. We need to amend the law there.
Yes, Dr. Cheng. Obviously, Taiwan is an independent jurisdiction. So does that mean that you're actually admitting that Taiwan is part of China by giving that reply? I understand that that's always been the case, and the basic law has actually stipulated that that's the case. So can you expressly say so? Well, according to Chapter 1 of the Laws of Hong Kong, we have already made it clear that the People's Republic of China includes Taiwan and the Hong Kong SAR as well as the Macau SAR. So that's been stipulated in Cap 1 of the Laws of Hong Kong. So are you referring to the Taiwan Administrative Region? So if I got it correctly, so he was referring to the Taiwan Administrative Region. So I was referring to the Hong Kong SAR as well as the Macau SAR. So are you trying to get bogged down on the text or the wording? Well, I'm not going to discuss the detailed procedures with you because the thing is, I believe that in the minds of Taiwan people, Taiwan is not an administrative region under the PRC. So what we are worried about your current proposal is that somehow, while we're talking about a case in Taiwan, how come it's been treated as if it's part of China? Okay, let me simply respond to another point. Well, just now the Secretary said that for individuals' safeguards, so there are also there are safeguards so that for political requests that would not be dealt with. So have you consulted legal opinions? So what's regarded as some political crimes? For example, what about Guiwen High and also the Causeway Bay bookstores case? Would that be treated as a political case? Bureau Director. Let me correct once again Dr. Chang's point. Under Cap 1, the Interpretation and General Clauses Ordinance, well, China or PRC includes Taiwan, Hong Kong SAR, and Macau SAR, so I have to correct it. And also what's meant by political crimes, that will have to depend on the merits of the case before one can decide if it's politically oriented, and that has to be decided by the court. And according to overseas experience, they would also look at the nature of the case before a determination is made. So we will also be making reference to those case laws. Yes, I'd like to remind members not to speak while you're seated before you've been asked to speak, because we can always hear that. Yes, Chen Ying. Yes, I think the triggering point involved a case of a 20-year-old woman who was killed by her boyfriend in Taiwan last year. And I can understand that family members of the victim would very much like this to happen. And therefore, I urge members to pass this legislative proposal as soon as possible, because we don't want to see Hong Kong becoming the haven of criminals. But then if you look at the MLAO and also the FOO, well, they came into effect in 1997, and up till now, we have only been able to sign agreements under the MLAO, and also for FOO, we've only been able to sign agreements with 20 jurisdictions. So I'd like you to tell us, before 1997, so what were the basis for coming up with these two pieces of legislation, and also how come after the reunification, well, we didn't sign any long-term arrangements with some of the major jurisdictions, including China. So why was that? And also in combating serious crimes, that's the international obligation of the Hong Kong SAR government. And you said that the two pieces of legislation have been in place for over 21 years. And for many fugitives, or cases involving fugitives have taken place. So other than the murder case in Taiwan last year, so over the past 21 years, how many requests have been received by the SAR government from other jurisdictions? So that has to be reciprocal. So with regard to jurisdictions outside of the ones that have signed agreements with Hong Kong, have there been requests from them, and how many cases are there? Bureau Director. Thank you, Mr. Chen, for your questions. Well, before the reunification, as far as I understood it from documentation, well, in the UK and also common law jurisdictions, we had arrangements with them so that we could negotiate with them on that basis. But then since the reunification, we had to come up with new legislation on our own. That's why the prevailing legislation was no longer in effect. That's why under Article 96 of the Basic Law, we've been authorized to sign agreements with other countries or jurisdictions on MLA agreements and also SFO arrangements. And if you talk about the figures, for jurisdictions where we have no long-term arrangements or agreements with, and if they made requests to us, at least 8 cases have taken place since the reunification, and we declined their requests because there's no long-term arrangements. As for those with long-term arrangements, And those that have made requests, well, we have made 24 requests to overseas jurisdictions, and out of those, 11 were met. And for others, they are still being processed, including the persons who have to be arrested. They are either not in Hong Kong or they've been arrested elsewhere. As to requests made from overseas jurisdictions, there were 66 cases. So those were made under the long-term arrangements, and 23 were already processed. With regard to negotiations with the mainland on a long-term arrangement, well, after the reunification, we have not given up on that. So we have not ceased our negotiation with the mainland authorities, and such negotiations are still underway. But then indeed, there are many things that have to be dealt with. That's why we have been taking that very seriously, and we're still in the process of negotiation. Claudia Mo. Thank you, Chairman. Well, Taiwan is part of China. Well, that's the state policy, and and therefore is indisputable. But then, with regard to the case in Taiwan, we all want to help. But then, according to what you said, if we have to start the arrangement, then you will have to make it open to the mainland as well. But then it's about how it's expressed in legal language. So under the FOO, Cap 503, the Fugitive Offenders Ordinance is stipulated that it's not applicable to any other parts of the PRC, but then according to what you said, Taiwan is part of China. That's why you will have to mix it up with China. But then in terms of the wording, can you just change it so that it's still not applicable to other parts of the PRC except Taiwan? So can you then apply it to Taiwan so that there'll not be this controversy? And second, if you just bulldoze it through this council, are you confident that the authorities in Taiwan will be willing to work with you, because they'll be treated as if they're part of China? That's their premise, and then they'll start the negotiation, let alone reaching an agreement with you. So are you confident in that, Bureau Director? Well, Ms. Mo's suggestion was just part of the problem that we are facing. Because as I've made it clear, other than dealing with the murder case in Taiwan, well, this case has also highlighted the loopholes under our legal system. And in 2 or 3 months, that can also happen to other jurisdictions where we have no such long-term arrangements. And therefore, we can see that it's a loophole. And therefore, it's not possible for us to just blindly deal with one single case instead of looking at the entire problem. And also another question that I would like to ask you, and myself as well. All right, with regard to the murder case in Taiwan, if the same happened elsewhere, let's say if it happened in, say, Spain, so you think that there should be this surrender arrangement? I don't think he should be asking us, all right, there are many Hong Kong people who do not have any confidence in the legal system in China, and there is no trust at all. I'm talking about mainland China. I'm not talking about Spain. Then you're actually opening the floodgate. We don't have time. Because we don't want this to be a Trojan horse. I don't want you to kill someone else by using this as a pretense. So can you tell us, and can you specifically refer to the case in Taiwan? I'd just like to make it clear. Let's say if it happened elsewhere, if it did not happen in Taiwan, if it happened in any other jurisdictions where we do not have this long-term arrangement, then you should talk to Spain. You should talk to the Spain authorities. Well, let's say if it happened in mainland China, does it mean that we should not deal with that? Does it mean that we should not deal with that? James Stowe, please do not shout in your seat. Please do not shout in your seat. We're talking about a long-term agreement. So please give me back the time. Well, I'm referring to two situations. One is about the transfer of cases. We're talking about special cases. One would be the long-term arrangement. Well, for long-term extradition arrangement, we're still negotiating with the mainland and also Taiwan. We haven't reached an agreement. But then would Taiwan be willing to talk to you then? Well, Taiwan, they have already suggested that there should be extradition of the fugitive to them, and we've been talking to them. But then that's without that basis. That's not on that premise. All right, we do take that very seriously. That case is very close to our heart. But then before you've been asked to speak, please do not speak while you're in your seat. Mr. James Doe, sorry, I have to warn you about that. That's the first time that I've warned you. Elizabeth Quat, the DAB supported this, and for the murder case in Taiwan causing the death of a young woman, we find it heartbreaking, and also we can see the victim's family has been suffering, and they'd like to see justice served. That's why, with regard to this proposed amendment, there is a necessity for that to be done. And also, concerning this case, I think it highlights that there is a very serious loophole in our laws, and that loophole is not something that can be plugged by reaching an agreement with Taiwan or other jurisdictions. That's why we are of the view that there is some importance to this, and therefore that should be implemented as soon as possible. Those from the opposition camp during the past few days, they've repeatedly politicized the whole thing, and they have also demonized this, and they are actually trying to say that there are political cases, or they just said that should Taiwan be treated as part of China and so on. So they try to use those as excuses to block the passage of this amendment. I think that's really very heartbreaking, because they've been talking about serving justice, but then the precise reason for amending the legislation is to make sure that justice is served. But then they're using these ridiculous reasons to block this amendment. So I think it shows that they are not practicing what they preach. So this is really regrettable. I hope that this amendment can be implemented as soon as possible, Chairman. I'd like to ask the administration this. That is, there are more than 100 jurisdictions where we have not yet signed such an agreement. So what is the timetable? So with this amendment, apparently it's more practicable, but then still, in signing a long-term agreement is a better arrangement. So what's the timetable from the administration, please? Thank you, Chairman. Well, for the arrangement for signing long-term agreements, that's part of our plan. Well, for the ad hoc extradition arrangements, we're talking about very special cases. And in fact, in negotiating with any jurisdiction on the extradition of fugitives and also under the MLAO, the first and foremost thing to do is to come up with a list of countries that we'd like to negotiate with. We have actually come up with more than a dozen or so countries, including Japan, Switzerland, and so on, and in Southeast Asia and also Europe, and even South American countries. There are some countries that we are approaching, and there are countries that we are talking to, including some European countries and also some Latin American countries. So first thing to do is to talk to them.
And we also need to sign draft agreements before we iron out the final agreement for signing. We will also consider, for example, how frequent our exchange is with the other jurisdiction, whether we have signed any bilateral international treaties or agreements, or our economic and trade partnership and exchanges. And we will also consider judicial cooperation in the past, our future assessment. So, Secretary, will a table be provided to us setting out the priority jurisdictions that you will proceed with negotiation. The other point I need to point out is that the opposition can always politicize matters and put them before livelihood matters. I hope they will not do that for this. Well, your time is up. Secretary, please provide supplementary information after the meeting. Mr. Alokhim, Dr. Elizabeth Quad, what are you talking about? What exactly? Are you talking about politicizing it, demonizing it? When are we doing that? We're now discussing this, and that is Secretary for Security John Lee has totally disregarded any basis of the negotiation and discussion between Hong Kong and Taiwan. Well, in 1998, Mrs. Regina Ip was then the Secretary for Security, and there were 5 principles laid down. And because of the major differences between our legal systems, between Hong Kong and the mainland, we need to be prudent. And she also emphasized that the Hong Kong government places utmost importance to Hong Kong people administering Hong Kong and a high degree of autonomy. Have you studied the five principles? Secretary, I don't think we should focus on a single point. For the legal loophole I mentioned, I mean to say that we do not have any long-term agreement for surrender of fugitive offenders. Well, in other words, you have not studied the 5 principles set out previously. Well, secondly, we uphold the same standard in dealing with all the... Well, we're not talking about the same principle. We're talking about the differences in our legal system between the two places. Well, have you studied this article by Gei Weiling? In fact, there were 2 expert meetings with a report of 140 pages. Can you explain this report to us? Can you say whether you've read this report? We're not talking about a long-term SFO arrangement with the mainland or MLA in criminal matters, but you're proposing to amend the MLAO and FOO, and if you set a precedent, Hong Kong can then surrender fugitives to the mainland. It has nothing to do with a 140-page report. Let me tell you, for the 140-page report, well, you might very well have not read it at all. In fact, there were 4 rounds of expert meetings, and there was a study on the surrender of fugitives in a report of 140 pages. And according to this expert, the FOO serves as a reference, but it may not entirely suitable for application between Hong Kong and the mainland on surrender of fugitive offenders. Have you drawn reference to the remarks made by the then Secretary for Security or the international expert? Well, this is only a 10-page document that you've submitted this time, but you haven't even set out these justifications. So what is the justification for amending the law? Are you competent as a secretary? For long-term SFO and MLA arrangements, we need to differentiate them with the one-off case-based cooperation, because what we're doing in this exercise is to amend the local legislation, that is CAF 503. Does it mean that after amending the local legislation, things will be reverted back to the original state? Well, in fact, for Shilin Prosecution Division in Taiwan, they welcome any discussion with you. Instead of discussing with them, the Security Bureau then proposes to amend the legislation for good, just using this case as a pretext. As in 2006, the Security Bureau mentioned that should such a legislative amendment take place, the public will be consulted. Can you answer, Secretary, whether you will consult the public? We welcome the views. And after issuing the electoral paper, the Security Bureau sets out on the website that we welcome views from the public. Now, I think, first of all, it is not fair to just focus on a single point, because we are talking about legal loopholes applicable to any jurisdiction with which we have not entered into any MLA or SFO arrangements. We need to tackle this loophole. Second, The objective of the legislation is to target certain cases. We referred to an amendment not related to the long-term arrangements. It's basically about the one-off case-based cooperation. Because we have indeed a difficulty in practice. Now regarding consultation, we welcome views from everybody now because the case happened a year ago and within a short period of time, and I'm grateful to the Department of Justice and the Security Bureau for conducting thorough legal research. We refer to the legislation in other countries such as UK and Canada, and we are drawing reference from their legislation for our local legislative amendment. Now we need to come up with a proposal. Before the proposal is finalized, I don't want to give a false impression or false hope to the grief-stricken family of the victim. I hope members would understand that we need to wait for the right opportunity to propose it. Now, in the future, when members discuss a bill in this council, you can also forward any views on our amendment. I hope members will understand this. Mr. Holden Chow. Thank you, Chairman. I speak in support of this proposed legislative amendment to plug the loophole. Last year, a Hong Kong citizen was murdered in Taiwan, but because of the lack of SFO arrangement between Hong Kong and Taiwan, the perpetrator could go scot-free because it is such a serious crime, and it is definitely unjust that the perpetrator could remain at large because of the lack of SFO arrangements. In fact, I have been in touch with the victim's family for over a year. I understand that they are grief-stricken because of this case. I believe the family members as well as the public would like to see the law being amended to plug this loophole. So regarding this arrangement, after the legislative amendment, the court will be the gatekeeper. We have a common law system in Hong Kong. And in fact, under the existing FOO and under the common law system, no fugitive offenders should be surrendered based on his race, religion, nationality, or political reasons. Otherwise, the court will reject such a request for surrendering. And also for other common law jurisdictions, there have been case authorities with lengthy discussions, and we also have case laws to follow. So under the common law system, the court can operate in such a manner to safeguard human rights. It is not the case that because of this arrangement, it is a breach of human rights. I believe that we should not mix things up so that the murderer could go scot-free. I hope that we can do justice to the family members of the victim because they are grief-stricken. So what's your question? I speak in support of this proposal, and I'd like the Secretary to explain a bit further about the court being the gatekeeper. Secretary. Thank you, Chairman, and thank you for the question about the court's gatekeeping role. In fact, we propose to amend the Fugitive Offenders Ordinance, CAP 503, and all the personal safeguards or safeguards on human rights will be preserved. And there will only be additional safeguards in our future exercise. And under CAP 503, in 5(1)(a), it sets out very clearly that if there is a request made to surrender a fugitive, the crime concerned must not be political in nature. And in 5(1)(3), it also provides that the request should not be made based on the person's race, religion, nationality, or political opinions. And in Section 5(1)(d), it also provides that the surrender request may not be prejudiced or prosecuted, punished, or detained, or subject to any restriction on personal freedom on account of his race, religion, nationality, and political opinions. And also, then the double criminality principle should apply, and it also sets out very clearly in CAP 503 that only 56 types of crimes. In fact, 46 types of crimes are covered under the surrender agreement, and these are expressly provided in CAP 503. Regarding safeguards on human rights and also types of crimes to be included, they were decided when CAP 503 was enacted. And our proposal is based on the provisions and restrictions set out in CAP 503. So all the safeguards and provisions in CAP 503 still apply. And all the legal and human rights safeguards would still apply for any arrangement made under CAP 503. Does any other member wish to speak? If so, please press the button now because I need to draw the line. Mr. James Toh, Deputy Chair. Members of the public, I'd like to say this to you. It is a very serious issue. I've been concerned about criminal matters, Hong Kong, and the SFO arrangements entered into with the global community for over 20 years. I am familiar with the background. I cannot imagine why Carrie Lam, Teresa Chang, and John Lee could propose such an amendment. If this is about resolving a single case or resolving the issue with a Taiwan authority, we could have sought approval from the CPG to discuss with Taiwan. In fact, 1 year ago, we could have entered into an agreement for the surrender of fugitive offenders with Taiwan. I believe the CPG would allow this to take place, but we haven't done it. We have been negotiating for an agreement for 20 years in vain. What about the loophole as mentioned by the administration? Who has created this loophole? Is it the fault of Hong Kong or China or the mainland? Because under the system in the mainland, without an agreement, no person should be surrendered to Hong Kong. However, for any person of any nationality in Hong Kong, including a Taiwanese, under the proposed mechanism, they can be surrendered to the mainland in one go. In other words, even without an agreement, we can act unilaterally to plug this loophole. I don't think this is the real purpose. I don't understand why, at this juncture, the administration still continues to undermine our legal system. If we are to solve this problem, I hope the administration would consider following the international practice in engaging a discussion with the Taiwanese authority, because Taiwan signed the international human rights agreement. I don't understand if Hong Kong government is trying to take the easy way out, or if there is any hidden agenda. In any case, such an amendment would affect everyone in Hong Kong, including Hong Kong citizens and any person in Hong Kong of any nationality. And the implications are so far-reaching that it far exceeds Article 23 legislation. Because even for Article 23 legislation, a ruling would be made by the court based on the laws of Hong Kong. However, there is no jurisdiction for a court of law in Hong Kong to rule on any matters relating to the mainland's legal system or whether the hearing is fair.
So our courts will only be able to look at the individual case to see if the facts of a case can be established. For a comprehensive agreement, that will have to be decided by this council to see whether or not a certain jurisdiction has a rule of law, whether or not there is independent trial, and whether or not they have independent lawyers or counsel system and so on. So this is a very comprehensive political assessment. Well, for some jurisdictions or places, we simply will not fathom or consider signing such agreements with them. And if we were to resolve this problem once and for all, this is not the right approach. Bureau Director, the Deputy Chairman's criticism has been rather severe, so you will have to do you want to respond to that? Yes, indeed. First of all, I have to emphasize that we are not targeting one single jurisdiction. We can see that there is a loophole, and we are applying the same standards in dealing with any jurisdiction in the world. So it's about an individual case extradition arrangement. And what we are proposing is something that we have already done our research on, including the UK, Canada, New Zealand, Australia, Ireland, South Africa. We have looked at those jurisdictions. And with regard to what we propose for the Chief Executive to do, in fact, it's like the Secretary for State in the UK, and also the President for South Africa, and also the Foreign Minister of Canada. So this is the same as what they are going to do. And also for human rights safeguards, we are not just keeping those under the existing law. We are actually adding more. And third, last but not least, please allow me to finish, because Mr. To, to a certain extent, has his own view on the mainland's legal system. But what I'm trying to say here is that the PRC has already had extradition arrangements or agreements with 55 countries, and with 64 jurisdictions, they've already signed MLA arrangements. And for those with extradition arrangements, those include France, Spain, Italy, Austria, and also South Africa. So these also include some European countries, and they've also got agreements with the UK, Japan, Canada, and the US, etc. But then for 20 years, we have not been able to sign that with them. Mr. To, please allow the Secretary to finish. I'll deal with your question later. In fact, as we have said, for long-term agreements and also the negotiations that we are doing with the mainland, that should be separated, because we are looking at all jurisdictions in the world that have not yet signed MLA arrangements, and we're talking about isolated special cases that have to be dealt with on an ad hoc basis. But then you've negotiated with the mainland for 20 years, and still we have not been able to reach an agreement with them. Deputy Chairman, within this conference room, you're the most senior member. You should know that you should not be shouting in your seat. I'm warning you for the second time. I'm actually walking out in protest, says Mr. To. Mr. Alvin YEUNG, well, the Secretary apparently was suggesting that the mainland legal system is something that has been praised by the international community. But what I'm asking is, how come we have not been able to sign such an agreement with the mainland for 20 years? That's because we don't trust the mainland system. So can the Secretary tell everybody in the world that there is no problem? We can fully trust the mainland, that there is a fair and open system, and there are human rights safeguards, and definitely there will be fair trials, and for every suspect that is tried, he'll be represented by a lawyer. So I'm sure even if the Secretary dared to say that, nobody would believe in that. Let's not forget that the proposed amendment is giving this tremendous power to the Chief Executive in Hong Kong. But then last year, our memory is still fresh, because according to the US report, it was targeting the Chief Executive in dealing with a surrender request made by the US authorities, and they were questioning whether or not there had been political pressure that have been exerted on the Chief Executive, and in the future, the CE would be the gatekeeper, and she might be subjected to political pressure in signing such a certificate. So how can we do anything about it? And please do not just put the ball in the court of the court, because there are a lot of limitations on the court, because just now the DAB members said that there's no political consideration whatsoever. Well, please don't be stupid, because if you look at the 41 items in the schedule, in fact many of them could have taken place on the mainland, including tax crimes. Well, if the mainland authorities were to use these as an excuse to arrest somebody, well, in fact, it's so easy. So I'd also like to say this to the pro-establishment camp. In fact, for those you're representing, in fact, many of them are facing such offenses. They may not be political in nature. So please do not just blindly support the administration's proposal to amend the legislation. And if the target is so grand, we are also very concerned. And also we also have full sympathies for the bereaved family of the victim in the Taiwan case. So please confine this to the Taiwan case. So that would resolve a lot of the problems. And I'm sure in this council there will not be this opposition, and we would also be in support of passing this amendment as soon as possible. So under what circumstances will the Bureau Director be prepared to confine this to Taiwan so that it would not spark such an outcry, so that there will not be this opposition in this council and in the community? Bureau Director, I'm here to listen to your views. And of course, what you said, that's your concern, will also be considered very carefully. It's not just you. Anybody's views in this council would also be listened to very carefully. First, under Cap 503, under the FOO, it's been made very clearly that the chief executive, in exercising any power that she's been given, she has to comply with the laws of Hong Kong. And if there should be any abnormal circumstances, I don't think that would happen, because the CE has to exercise her powers in strict accordance with the law under Cap 503. I'm not talking about the laws. I'm talking about political pressure. If the chief executive is under pressure from elsewhere, so are you saying that the chief executive will say this to Beijing, that I'm protected by Cap 503 and therefore I would not be subjected to any political pressure in exercising any power or in making any decision? She'll have to act in strict accordance with the laws of Hong Kong. That's number one. And number two, for any jurisdiction, I'm not emphasizing, or we should not be focusing on any particular jurisdiction. Well, that jurisdiction cannot make a request for an offense that is not in the schedule of our legislation. And also, the law also makes it clear that whatever law that they are citing, and if the case is in conflict with the human rights safeguards under our laws, then the court will also have to deal with such representations. The person in question will be able to make representation under each and every one of those safeguards. Dr. Kwok K, well, I've never seen officials acting so outrageously. So you're suggesting that the PRC will be able to protect our people. Look at Wang Quanzhang and also other people. Well, there's another case involving Gui Wenhai. There's a traffic case in 2003, and yet he was arrested in Thailand, and he appeared or he was seen on the mainland. And now we also have this Causeway Bay bookstore case involving Lam Wing Kei. So we know that on mainland there is no rule of law. And also under the FOO, yes, we do have the power to do something about it. Basically, through the chief executive and this council and also the court, we could do something about it. Now you're trying to open up this loophole. That is, the CE will be able to make this administrative or executive arrangement, and you're comparing ourselves with the Prime Minister in Canada and so on. Our chief executive has been elected by a small circle, and she was supported by the liaison office, and then she has been elected by the pro-establishment camp. And now you're suggesting that she can protect Hong Kong people. This is even harsher than Article 23 legislation, because the case under Article 23 will have to be tried in Hong Kong. But then in this case, you're actually talking about sending somebody back to China. If you're trying to protect the family of the victim, well, this new legislation can just apply to that Taiwan case. So it's a one-off case. But then basically you're not trying to resolve this problem. And secondly, you're trying to change Taiwan into part of China. This politically is a murder of the relationship between Hong Kong and Taiwan, because originally Hong Kong is standing in this position where we can still establish very good relation with Taiwan, and yet for political reasons we have avoided taking many actions, and now you're forcing us to take this approach. And I don't know what Taiwan is going to do, and if they reject our request, basically they've already done what they can. All right, they can just decline the request, but then basically you'll be able to do whatever you want for the mainland. You're not trying to resolve this murder case, because if you're trying to resolve the murder case, then all you need to do is to sign an agreement with Taiwan on this case. Well, for inciting trouble and so on. Well, basically they can do anything they want. And every year for on June 4th, we have also got this vigilance, the candlelight vigil and so on, so they can arrest everybody. So you're undermining the rule of law in Hong Kong, and that would also render the one country, two systems in existence in name only. So if you're just trying to do this for this murder case, then why can't we do this on a one-off basis? Why can't we just apply this to the Taiwan case? So can you answer this question, Bureau Director? Well, Dr. Kwok made a number of arguments. So my question is, why can't this be applied to the Taiwan case alone? So please do not take us up the garden path. Well, I have to emphasize that if we were to invoke Cap 503 to trigger the extradition arrangement, then the case will have to take, we will have to look at the double criminality principle. That is, if the case happened in Hong Kong, it's also a crime. So if it's not a crime in Hong Kong, then we cannot just extradite the fugitive. And we have already made that request. Taiwan has already made a request to us. And if it's just an ad hoc approach, if it's just a symptomatic approach, let's say 3 or 4 months down the road, there is a case happening in a jurisdiction where we still don't have such an agreement with, then what are we going to do? So this case has happened. It obviously tells us that this is happening. So are we just blindly going to turn a blind eye to this? I'm not saying that I will just let it go. I'm just asking how come it cannot be a one-off approach targeting the Taiwan case. He has not answered the question. Your time is up, Dr. Kwok. I've already given him 3 minutes to answer the question. I've already answered your question, Dr. Kwok. I've already said that if we just focus on the murder case in Taiwan, then 3 or 4 months down the road, if something similar should happen elsewhere, and if it's also another jurisdiction that we do not have such an agreement with, then are we going to just let it go? So we know very well that this can happen, and therefore we will have to deal with this legal loophole. Mr. Dennis Kwok. Well, the AJLS meeting back in 1998 on the 12th of October. Back then, Ms. Elsie Leung was asked about this, and she said that because the legal system in Hong Kong and those two jurisdictions are different, in particular, they have capital punishment. That's why we have not yet been able to reach an agreement with them. And she also emphasized that any agreement would also have to be able to stand up to the premise that we have to safeguard human rights and so on. But then since 1998, what has changed? So much that you can be rest assured that you can sign this extradition arrangement with the mainland authorities. Before you answer the question, I'd like to remind you that according to the World Justice Report, right now, in terms of the ranking, mainland China, in terms of human rights safeguards, do you know the ranking of mainland China is 108? So there are several countries that are below them, Zimbabwe, and also Ethiopia, and also Iran. So are you rest assured that the legal system on the mainland will be able to give the fugitive a fair trial? You also emphasize that under Cap 503, what are the safeguards? Within 6 months, the trial will have to take place.
We've seen so many cases in the mainland in which the suspect was arrested and detained for so many years, and then a trial will be conducted behind closed doors, and not even family members of the suspect could attend the trial. How can you make sure that Hong Kong people would be given the basic human right protection as they are put on trial in the mainland? Well, I'll answer Mr. Dennis Kwok's question in a moment. Well, don't waste my time. Please answer me now. I need to respond to the quote that Mr. Dennis Kwok said that the purpose of this legislative... Well, please answer me. Then are you going to sign an SFO with the mainland? Yes or no? Don't waste my time. We have been discussing with the mainland, so the answer is yes. Well, this is a legislative council. We have been saying that. So answer me. After signing the SFO agreement, how do you ensure the fundamental protection of human rights will be given to Hong Kong people? Well, please be fair. Well, but you're not being fair to Hong Kong people. You say I'm not fair. Well, answer me. Well, I have constantly been interrupted. Mr. Dennis Kwok, please allow ample time for Secretary to answer your question. He is wasting my time. I'll give him ample time to respond to you. I think it's all about solving problems. I don't want us to be confrontational and irritated. I think we're all focused on resolving the issue. I'm not just referring to one single jurisdiction. This is about how such matters should be handled around the world, regardless of the jurisdictions. And also, since the resumption of sovereignty over Hong Kong, we have been discussing it with the mainland. This is not the only discussion we have had because of the case, and for this legislative amendment, this is not done for a single jurisdiction. Third point, Mr. Dennis Kwok has his views on the mainland's legal system. I will not try to convince him to change his mind, but I also need to reiterate that for the figures I mentioned, many Western countries have signed extradition agreements with the mainland, including 54 jurisdictions on extradition and 63 on mutual legal assistance. I think when these jurisdictions signed agreements with the mainland, they have pondered the questions raised by Mr. Dennis Kwok as well. The most important thing is to have sufficient safeguards on human rights in our laws. Now, for France and Italy, Spain, Portugal, when they sign agreements with the mainland, I believe these jurisdictions would process the issues raised by Mr. Dennis Kwok. I understand your views on the mainland's legal system, but there is no single view on this matter, and we do have countries around the world having faith in this kind of SFO arrangements, and they have signed the corresponding agreements with the mainland. I need to ensure that human rights are sufficiently safeguarded, and this is so under Cap 503, and that is to say there will only be additional safeguards on human rights. Mr. Poon Siu Pik. Thank you, Chairman. It is normal to have identified loopholes in our laws and try to plug the loopholes through legislative amendments. Now, according to the paper, we have 32 jurisdictions having signed MLA agreements with Hong Kong, and also 20 jurisdictions having signed SFO agreements with Hong Kong. Now, for extradition agreements with the mainland, 50+ jurisdictions have signed such agreements. I don't know what the difficulty is facing Hong Kong, such that we only signed so few SFO agreements with only 20 jurisdictions comparing to 32 MLA agreements. I want to know the discussion involved and whether there are areas for improvement and whether there is a need to increase manpower. And from the paper, my understanding of the legislative amendment is that for homicide cases of a serious nature in another jurisdiction, of course, the chief executive will need to initiate the proceeding, followed by court proceedings. Also, for appeal to be available at the Court of Final Appeal. Let's say if somebody commits homicide in a number of jurisdictions, does it mean that he will only be extradited to a single jurisdiction but not other jurisdictions? Now, there is a concern that this system will be abused and that the safeguards on human rights will be undermined. I want to know from the administration whether there are additional safeguards to allay their concerns. Thank you, Chairman. Thank you, Mr. Poon. We've signed MLA and SFO agreements with different jurisdictions. Well, for the shortest time frame, it took us several years, and for the longest time frame, it took us more than 10 or 20 years. Different jurisdictions have their own priorities on signing agreements with other jurisdictions. These jurisdictions would consider their own interests, for example, and there may be some internal mechanisms for these jurisdictions. Now, for example, after signing an agreement with a jurisdiction, within its own legal system, it had to prepare its own local legislation, and also during the discussion process, some substantial amendments had to be made. And also, in some jurisdictions, because of change of government, we needed to start the negotiation process again. As a result, some negotiations were quite lengthy, even beyond our control. In fact, for one jurisdiction, the discussion has gone on for 20 years, and it is still ongoing. As far as our priority is concerned, we would start with jurisdictions with which we have more frequent legal exchanges, and we will prepare draft agreements and then some further negotiation before we finalize the agreements. So it's a lengthy process. Regarding the question on a person committing crimes in a number of jurisdictions, the way to handle the case is that the requesting party will take the initiative. So if a person commits crimes in different jurisdictions, it depends on which jurisdiction makes a request first. Now, according to the law, there is also a stipulation on multiple requests or concurrent requests. For example, which jurisdiction makes a request first, how serious the offense is, and also actual operation difficulties. Mr. Jimmy, well, we have an effective and established legal system, and that is we have due process, and through that we provide safeguards on human rights. I hope the administration cannot confirm with me whether this is correct. After receiving a request, the chief executive would sign an ATP, that is authority to proceed, for a provisional arrest warrant to be made and for this person to be brought to in front of the court. And based on the information available to the court will decide whether to issue a formal arrest warrant. And once such a formal arrest warrant is issued, there will be an avenue for this person to appeal to all the way to the Court of Final Appeal. And if the court's ruling is such that the warrant is upheld, there is also an avenue for the person to apply for habeas corpus. And if this application is rejected, the person can still appeal all the way to the Court of Final Appeal. And at the same time, the person can make a torture claim. And again, for this claim, it can be appealed against, should it be turned down, all the way to the Court of Final Appeal. So that after going through all the court proceedings, if the court should find that this person should be detained and surrendered, ultimately the chief executive will make the final decision. So the chief executive will need to make two decisions: first on the issuance of provisional arrest warrant, and then second, after going through all the court proceedings, the CE will then decide whether the order for surrender should be made. And meanwhile, the suspect can also institute proceedings for judicial review against the final order made by the chief executive for his surrender. And that the judicial review, should it be turned down, could further be taken to the Court of Final Appeal. And ultimately, if the court decides that the person should be surrendered, then the person then at that stage will so be surrendered. Thank you, Chairman. And thank you for the very detailed and lengthy question and statement put by Mr. Jimmy Ng. I think his statement is correct, but I need to correct one point. For the chief executive's authority to proceed, this is not the provisional arrest warrant per se. In practice, well, if we wish to surrender a fugitive offender on a single case basis with jurisdiction A, we need to reach an agreement on this with this jurisdiction, and then the chief executive will issue the authority to proceed together with this agreement, and these documents would be submitted to the court for the application of an arrest warrant so that the court will be aware of such a case. And then under Cap 503, the court can then deal with the case and also consider the agreement. So it is the chief executive's ATP that will initiate the proceedings. But the law enforcement authority will also need to apply with the court for a provisional arrest warrant. Now, regarding the rights for the person to appeal and all the safeguards mentioned by the honourable member, everything is correct. The only point I'd like to make further is that the court has absolute right to veto any application for surrender of fugitive offenders, because if there is any breach on any human rights safeguards mentioned above, the court will make immediate release of the person, and that no such proceeding will be further initiated. So only with the consent of the court will the person be surrendered. And should the court turn down such an application, the chief executive has no authority to proceed with the surrendering request. Mr. Eddie Ju. The Secretary keeps saying that there is a loophole in the FOO, and I need to explain to the public very clearly that when the FOO was enacted, at the outset, it already says that it doesn't apply to the People's Republic of China. This is not a loophole, this is rather a firewall. The firewall is put in place because Hong Kong people do not trust the mainland's legal system, and we do not agree that any person should be surrendered to the mainland for court proceedings. This is very clear. The administration, however, is saying the contrary. It is saying that there is a loophole in our law. It is regrettable. I'd like to ask this question from Taiwan's perspective. Now you are using this homicide case in Taiwan as a pretext, and then you propose that something should be done because a request has been made from the authority in Taiwan, and that you would have a closed-door discussion with the Beijing government, and then you say that there is justification for you to uphold justice for this homicide case. Now, Secretary, you've come up with this idea. Before or after you've made this announcement, have you or will you tell the Taiwanese authority two things? First, the premise of this legislative amendment exercise is for the Taiwanese government to acknowledge that Taiwan is part of the PRC. Is that the rationale of your legislative amendment? Would you say this to the Taiwanese authority? And also, will you or have you explain to Taiwan that this legislative amendment hasn't only to do with the homicide suspect being able to be surrendered to Taiwan, but rather in the future, all Taiwanese citizens in Hong Kong, upon the Beijing government's request for the Hong Kong SAR government to surrender such Taiwanese national, the similar risk would occur, and that is once the CE makes a decision, such a Taiwanese national will be arrested, and then with the consent of the court, the Taiwanese national would be surrendered to the mainland. Have you explained this to the Taiwanese government? If you haven't done that, will you say this to the Taiwanese government?
Bureau Director, thank you. Well, Mr. Chu, let me emphasize once again that this is not just about the Taiwan case. Please do not repeat your answer, Bureau Director, because I only have slightly more than 2 minutes. Yes, I think the question is very clear. Bureau Director, first, we are amending the laws of Hong Kong, so that's within the autonomy of the Hong Kong SAR. Therefore, there is no need for us to consult anybody outside of the Hong Kong SAR. And after the laws of Hong Kong have been changed, so you're actually giving me this basis to talk to any jurisdiction. You can refer to the Taiwan case or any other case, so we can reach an agreement with them targeting this particular case. So we are targeting this particular case as to how the fugitive will be surrendered and what sort of evidence will have to be made available before we think there is a justification for us to surrender that fugitive. So it's only about this case. So whatever you said just now will not be applicable, because what we intend to talk to the Taiwanese authorities will not be applicable. You talk about surrender of fugitive and also a surrender request and so on. Of course, we will be contacting them on this, and we'll be looking at this particular case as to what needs to be done. As to any agreement that is to be reached with them, it will only be applicable to this particular case. So he's confirming that both before and after the passage of this amendment, they are not going to talk to the Taiwanese authorities on this. Is that the case? Well, your time is up. Next, Mr. Ted Hui. Chairman, I'm speaking to strongly object to the amendment proposed by the administration with regard to the surrender of fugitive, because by making this amendment, actually everybody in Hong Kong will be put in a very dangerous or precarious situation, because for anybody in Hong Kong and outside government, including the mainland authorities, they can always accuse us of something that is framed, and then Hong Kong authorities will be asked to arrest any one of us, and then we can also be surrendered to the mainland authorities for trial. Does any one of us, can any one of us trust the mainland authorities and legal system? Do you think it's prejudice? Is a fact? So Hong Kong people's human rights will be undermined. This possibility cannot be dispelled. Well, you can say that, we are not targeting the mainland government. You say that there is this loophole and we can't do it with Taiwan, then you can just sign an agreement with Taiwan. Let me emphasize that under Cap 503, under the FOO, the Fugitive Offenders Ordinance, you said that it's not just about Taiwan, it's not just about mainland, it's about any other jurisdictions. In fact, we can always have this one-off case-based approach, but then it will have to be done by way of subsidiary legislation. You will have to come to this council and you will have to disclose some details, and the fugitive can flee. But then have you noticed that under the rules of procedure, under Rule 88, we can also have closed-door meetings, and any member can always move that, members of the public and reporters will have to stay away from our meetings. We can always hold closed-door meetings. So how can anything about the case be disclosed? And also under the Powers and Privileges Ordinance, in fact, any documents in this council, any officers of this council, or any staff of this council, we can be protected. We don't have to give evidence in court. So how can there be unfair trial? and some members also suggested this, and I also agreed. That is, this is just a pretext. You're not trying to plug a loophole. You're actually trying to open a floodgate so that Hong Kong government, including the chief executive, will be able to exercise powers to surrender anybody that the government doesn't like to any other government or any authorities for trial. Well, under the FOO, this council has been given certain powers to look at these ad hoc cases so that there can be one-off surrender. How come we are surrendering this power instead of having this council decide which party should be surrendered, and we are giving this power to the chief executive and the chief executive alone? This is not what an accountable government should do. In fact, this is a government that is accountable only to the Beijing authorities rather than the Hong Kong public. You also refer to other jurisdictions whereby the head of government or the head of the parliament will be making such decisions. The countries that you refer to, including the UK, Canada, and South Africa, they are elected governments, and the head of government can step down because they have to be accountable to the voters. But then, will you be doing the same? So this amendment obviously is a Trojan horse, and obviously you have other ulterior motives. You're trying to open up this floodgate so that Hong Kong people, basic human rights will be undermined. And I'd like to listen to your response, Bureau Director. First of all, Mr. Hui, you have your wrong views on the mainland's legal system. I think all Hong Kong people have this view. We do not trust their legal system. Well, can you allow the Bureau Director to respond? Please do not speak while you're in your seats. Well, I can give you some figures. I think that's back in 2011. Statistics show that Hong Kong people working on the mainland are over 170,000, and every day we have some 200 to 300,000 people who would go to the mainland for work. And if the mainland's judicial system is something of a concern to these people, then I'm sure these people would not have done the same. That is, we would not have had such a large number of people working on the mainland. And also, in discussing any particular case, well, when we try to arrest somebody, we would not just be able to arrest him on the first instance. We might have to wait for other chances if we are not able to do it on the first instance. That's why we have to keep the case secret. But then this council can also hold closed-door meetings. Have you noticed that? Well, Bureau Director, well, we have to keep the case strictly confidential. So I'm sure you would understand it. Even in overseas jurisdictions, they would also have to understand to what extent are we able to keep the case confidential. And also, we have this one-off case-based approach. I do not see why overseas jurisdictions are able to do it and we are not. Because these are also common law jurisdictions, and we also have the same safeguards, so we can keep the case strictly confidential, and we can also make sure that the other parties would also have faith in us that we are able to keep it confidential, or else it would not be meaningful at all. And also, what we are talking about is that the amendment will be scrutinized by this council, and we will be tabling this amendment to this council. And what I'm trying to explain to you is that if we are not able to deal with these two difficulties, then the murder case in Taiwan can happen in any other place. It's just a matter of time as to when it's going to take place. And then once again, we'll have to say that, sorry, we are not able to deal with it. I don't think that's the right approach. That's why we are moving this amendment. How come other jurisdictions are able to do it? And we can see that in many other jurisdictions, they've also signed such MLA agreements with the PRC. So how come we have such misgivings about this? We don't think we should be wearing a tainted glass in looking into such cases. Yes, Mr. Wong Kwok Kim. Chairman, yesterday I read I watched this news report with regard to Western countries. They're actually hysterical in suppressing Huawei. And I can see that many members of the opposition camp are actually also very hysterical when it comes to dealing with the mainland, and they are even worried about including Taiwan as part of the PRC, and they are also worried about that. I don't know if they support Taiwan independence, or else why would you be concerned about this? And in fact, this amendment is a very simple one. So this is a one-off case-based approach in surrendering fugitives. So we're talking about a case-based approach. In other words, it's done on a case-by-case basis, and every time we will look at the merits of the case before a decision is taken. And many members, including those from the legal profession, I don't know whether or not they are just they are just naive or what. So they are actually linking this up with the negotiation that has been taking place between us and the mainland authorities. We're talking about a long-term arrangement. They are mixing up the two. Actually, we are talking about a one-off case-based approach now, and I think they are best at this. That is, this is always a three-step approach. They try to demonize everything that is proposed by the administration in relation to the mainland authorities. They try to demonize everything. Second, they are trying to adopt this alarmist approach. They are trying to scaremonger the Hong Kong public. They are talking about very extreme cases, something that they themselves do not believe in. And they said that after this is passed, you no longer have any human rights. You don't have any freedom of movement and so on. Well, this is not the first time that has taken place. In fact, we have also encountered this when we dealt with the co-location arrangement and so on. All right, you talk about violating one country, two systems principle, and they actually said that public security officials would be arresting Hong Kong residents at the West Kowloon XRL terminus. In fact, many people have been using that, and even pan-democratic members have been using the XRL themselves. So that is an over concern, or are they trying to demonize everything involving the mainland authorities? So, well, we are trying to plug a legal loophole. And if you look at it from that perspective, and also from the perspective of dealing with the Taiwan murder case, I think the FTU is in total support of the administration's proposal to amend the legislation. There is a necessity for us to do it, because without the amendment to plug the loophole, it's not hard to see that other people will copy, will be copying cat. Well, it's not just about Taiwan, because there is no such an extradition arrangement. All right, when you go to Taiwan, I can just kill you, and then I can just come back to Hong Kong scot-free. So it's not about a one-off arrangement. It's about a long-term safeguard. So I'd like to ask the Bureau Director, to what extent are we able to ensure that this law will have retrospective effect? Because in Macau, there's also a financial case involving two Hong Kong businessmen who were problematic, and they've been convicted in Macau, and now they are still able to go scot-free in Hong Kong. So can we do anything about it? Thank you, Chairman. Thank you, Mr. Wong. Well, the wording is very clear. So long as the requesting party, if is still within their prosecution time limit, and also if the conviction is still within the timeline, then it will be applicable. But then I talk about strict confidentiality. I'd like to elaborate on that. Under the existing laws, whatever you do after the scrutiny is completed and after the amendment is passed, we will have to gazette it. And then by the time when it's gazetted, it means that the case and also the concerned parties, their details will be disclosed, and therefore we will not be able to ensure that the case is kept in strict confidentiality. Ted Hui, I'm warning you once again. Yes, Mr. Kwok. I think the matter is very simple. I think they're just complicating the matter. Well, for the Taiwan murder case, I think the problem is before us. And what we are thinking about is how we can resolve this case. And the Bureau Director, to what extent are we able to ensure that the case is kept in strict confidentiality? with regard to the opposition camp, all right, they are just phobia about political cases. I think, it's a terminal a disease that cannot be treated.
對於呢啲政治嘅偏
Well, they are so politically biased that it is getting ludicrous, and they've become radical. The Hong Kong SAR government, especially the Security Bureau, in handling the matter, has been following every rule, and the opposition camp's concerns are simply unfounded, whether it's for political or religious reasons. That's simply not true. So definitely we're only talking about offenses involving homicide, rape, or serious robberies. However, the opposition camp continues to escalate the matter and continues to spread panic, whilst turning a blind eye towards the infamous homicide case in Taiwan. I don't know whether the opposition camp is questioning the wisdom of Hong Kong people, or are they just trying to spread fear? We're just trying to come up with practical ways to resolve the problem. And the opposition camp's political phobia is totally irrelevant. We definitely support this proposal, and that the law should be amended to expeditiously solve the problem facing us. Any response, Secretary? First of all, I thank Mr. Kwok for his support. I must emphasize that we have human rights safeguards, and they will be preserved in terms of individual cases. Depending on circumstances, on a case-by-case basis, we can provide additional safeguards on human rights. Dr. Priscilla Leung. Chairman, first of all, when we talk about the surrender of fugitive offenders arrangements, the primary objective is to combat crimes. In the past, we made agreements with other jurisdictions. The purpose is clear, and that is to protect the public in their own jurisdictions so that the perpetrators of crime would not go scot-free. Internationally, there are standards on the surrender of fugitives. First of all, there is a double criminality principle, and that is the crime must constitute an offense in both jurisdictions. So if there is a question on whether the crime constitutes an offense in one of the jurisdictions, no surrender of fugitives will be made. Second principle, we call these persons political criminals, and these political criminals will not be surrendered. Third principle, if the jurisdiction has a death sentence, and if the jurisdiction makes a request, then the other jurisdiction which does not have any offense punishable with death will need the requesting party to assure that such punishment will not be meted out. And starting from the Zhang Qikang case in 1997, we have had a lot of discussions in Hong Kong. Discussions by the academics and legal sector, and also we have a number of murder cases requiring the surrender of fugitive offenders. In fact, the person committed crimes in a number of jurisdictions, and concurrent requests could be made by multiple jurisdictions. The point is, we see a serious crime such as drug trafficking or homicide being committed in a jurisdiction, and regarding this case actually happened in Kai Ching. The victim lived in Kai Ching, and in the past, we didn't understand this concept, and that a Hong Kong citizen who commits a serious crime outside of Hong Kong cannot be reined in Hong Kong. But in future, we can have this precedent. Well, Ms. Claudia Mo asked whether we could set an exception. The answer is no. It is against the one country, two systems principle. The fundamental principle in Hong Kong is that we must not allow an exception for Taiwan in our legal system. We must not give this impression. So I think if we have this agreement that we should not tolerate such serious crimes being committed in Taiwan by Hong Kong citizens to go scot-free, we need to be a gatekeeper. And for the Lai Chang-sing case, well, in Canada, the case was processed for over a decade. And then there was an undertaking that he would not be punished with death. And that case involved a very serious economic crime. Now, what about common values, human rights, so on and so forth? I think the courts in Hong Kong have experience. So perhaps we can think about, for example, SFO agreements having signed by the mainland authority and Taiwan long ago. And in these cases, they have observers. Can we give this a thought to enhance transparency? We should put our people's interests first instead of saying no to the idea, so that these perpetrators of serious crimes will go scot-free without any legal punishment. You note the comment, Secretary? Yes, thank you for the comment. Well, members, we still have 12 members waiting in line. Our meeting will be adjourned at 12:45, and I'd like to hear members' views on the matter. Let's finish this item, and then we can also vote on the motions moved without notice, and then we will adjourn the meeting. For items 5 and 6, they will be deferred to the next meeting. Do we agree? Yes. Please continue. Mr. Kenneth Lau. Chairman, I need to make this solemn statement here. I need to talk about the fallacies of some members and the administration. Well, just now, Dr. Priscilla Leung talked about SFO arrangement signed between mainland and Taiwan. In fact, it carries a very narrow scope about Jinmen, about smugglers only. So that agreement is very specific. Second, I need to clarify this point. Under the FOO, we have 46 offenses applicable, not just about serious crimes such as rape, murder, arson. We have, for example, 10, 12, 16, 30 all the way to 44. Let me give you an example. Number 10 is offenses relating to bankruptcy. 14 relating to the SFO, Securities and Futures Ordinance. 13 or 14 offenses relating to protection of intellectual properties and trademarks. All these offenses are covered under the FOO. As for the actual operation, I need to explain to the investors coming to invest in Hong Kong. In fact, the person concerned is not required to be present in the mainland. He is not required to be physically present as long as the crime is committed, say, on a computer, and if the offense is one of those set out among the 46 crimes, then this person may be surrendered to the mainland for punishment, because for the 46 offenses, they do not just relate to serious crimes such as murder, arson, rape, because some crimes may relate to tax or tax evasion or failure to file a tax return. They may not be as serious and as widely reported as this homicide case. So the scope of offenses is really wide. Another point, Sir John Lee compares our system to the other system in the jurisdiction where the Secretary of State or Minister of Foreign Affairs would be the official involved. Well, but these are elected officials. I don't think the president of South Africa would be a suitable comparison. We must follow strictly the CBG's instructions. If the C is to make a decision, I don't know how you can reassure us that this will not be a political decision, because under this proposed mechanism, LegCo will be deprived of vetoing power. Now, you mentioned that the one-off case-based surrender arrangement is impractical, but this practice has been put in place long ago. Why haven't you changed it? And in fact, the rules of procedures allow us to have closed-door meetings. And in fact, we can finish a discussion within 24 hours. And you also know that we can choose not to provide a lot of details in the Gazette notice. We can just state the country, so on and so forth. And you haven't considered all these options before you float this proposal. You need to respond, Secretary. Yes, I need to clarify some inaccuracies. First, to my knowledge, for the agreement signed between mainland and Taiwan, they have an agreement relating to mutual legal assistance on criminal matters across the straits, and also the surrender of fugitive offenders arrangement across the strait. So there are two types of agreements. And I think Mr. Leung is inappropriately spreading panic about the 46 offences. When LegCo scrutinized the bill before enacting Cap 503, we examined these offences and we agreed that these are common serious offences. And if you suggest now that these should not constitute serious offences, but in fact, the bill was thoroughly scrutinized. But now you are expanding the jurisdiction because Somali and South Korea, I don't think these are the relevant offenses. But please allow Secretary to respond. For the 46 offenses, they must also constitute a criminal offense in Hong Kong. Well, you mentioned filing tax return, say if there is misrepresentation in the tax return, it is a criminal offense in Hong Kong, but it also depends on criminal intent. Well, unless you have no faith in our own legal system, I think you're just spreading panic about confidentiality, about closed-door meeting. In fact, for closed-door meetings, there is no absolute guarantee that there is confidentiality because it needs to be published in the Gazette before it takes effect. And in this exercise, the details will be disclosed. And these are security issues we find it hard to tackle. Mr. Leung Chi-Chung. A Hong Kong citizen was murdered and the suspect returned to Hong Kong, escaping criminal liability. I don't think anyone in Hong Kong would agree that this is right. I think the purpose of this legislative amendment exercise is to tackle the issue so as to bring the perpetrator to justice. And we're also doing justice to the victim's family. So I think we are just upholding justice, and I think the public would agree. For the opposition camp in this council, I think they are panicking and they are spreading fear to every corner in Hong Kong, such that everyone in Hong Kong would be in fear, and they could then stir up more conflict between Hong Kong and the mainland. It doesn't matter to them whether we are doing justice to the victim or their family. I hope the administration would further explain this proposed amendment. Because according to some pan-democrats, some people would send to jail in Chin Chong, and some people would be arrested for no reason. Well, Mr. Jimmy just now, as a lawyer, explained the procedures in detail. I don't think everyone could grasp exactly what he means, especially for the general public. So I think for MLA in criminal matters and SFO arrangements, what rights are given to the person in question? Even for Pan-Democrats, if you commit a crime in the mainland or in Taiwan, you will also be brought to justice. At the same time, you will be given appropriate human rights safeguards. Mr. Chiming just now mentioned the multiple avenues available to the person concerned, and if you are familiar with the system, it could go on for 3 to 4 years.
Well, in Hong Kong, actually, they can even apply for legal aid, so they don't have to spend a cent, and then they can uphold their human rights. All right, please. You should not be scaremongering. You should be standing on the side of justice. And Hong Kong people do have the intelligence to tell whether or not you're lying and that you're spreading rumors, and then you'll be losing your votes. So that's your own loss. So I'm not going to dwell on that. My question for the Bureau Director is this. Okay, there are some sayings that well, they are concerned that we might not have enough votes to pass this. What about having the sunset clause? Is that possible? Will that give rise to such amendments being rendered ineffective? Bureau Director, thank you. What we are facing is not just about this case. It can also happen tomorrow. It can happen in the future. So if we just deal with this particular case, so if we just deal with it as a one-off case, but what if it happened again 3 or 4 months later? Are we going to have another special amendment just for that case? Because we know very well that it can happen. So we should be facing this squarely. We should be dealing with it once and for all. So I'll be listening to all views, whether they come from the pro-establishment or the opposition camp. But then we have to plug this loophole. Should we allow this loophole to continue to exist? I don't think that's the right approach. We should adopt a consistent approach so that we would be reasonably dealing with all these cases, both this case and other cases that could happen in the future, because this case tells us that it could happen. Next, Mr. Chiang Kwok-Kwan. All right, for the Taiwan murder case, the fugitive has come back to Hong Kong, and because we don't have this extradition arrangement with Taiwan, that's why nothing can be done about it. And the bereaved family, that is the victim's parents, have been working very hard during the past year in order to seek justice for their daughter, and yet nothing can be done about it. That's why this is really very sad. And well, for the relations or exchanges between the Taiwan Strait, we cannot say that it's not going to happen again. In fact, it could also happen to someone whom we know. And we must not deny this fact that is in Hong Kong, we do have this legal vacuum. We can also become a fugitive's haven. That's why, Chairman, I support this cooperation arrangement, because this is a proposal, and the Chief Executive will be issuing this certificate so that the fugitive can be arrested, and the court will be the gatekeeper, and it will decide whether or not this arrangement or this surrender will take place. And there are also safeguards, but then according to my observation in recent years, for anything that is suggested in this council involving Hong Kong and the interaction between Hong Kong and the mainland, or if there is any proposal for any collaboration, for example, for the Belt and Road Initiative, so long as the motion involves the Bay Area and also the co-location arrangements and so on, well, inevitably, the Pan-Democrats will criticize them, or they would just say no to it, or they would say that they would also be spreading this rumor of the end of the world, and so on. So, well, they are trying to distract us. And this amendment is to prevent the fugitive from fleeing Hong Kong. But then they are trying to politicize it, and they are actually trying to question the Bureau Director that this proposal would also have implications on whether or not Taiwan should be treated as part of China and so on. Well, we are trying to seek legal justice. This is a mutual legal assistance arrangement, and we should not be using this to incite trouble. We should not be inciting people's emotions by playing this up. Well, they have been criticizing the Bureau Director, and yet they simply would not allow the Bureau Director to respond. And even before the Bureau Director spoke, they said that he was speaking nonsense. Well, if we just blatantly ignore this legal vacuum, if we are not able to have this MLA arrangement in place, then how can we help the victim's family to seek justice for the victim, and how can we seek justice for the parents of the victim, and how can we prevent Hong Kong from becoming a fugitive's haven? Thank you. Thank you, Chairman. Thank you, Mr. Jiang. Well, Mr. Jiang, you said that if our proposal is not passed, then what will be the consequence? Well, first, the Taiwan murder case cannot be dealt with. In other words, the fugitive will remain in Hong Kong. And in fact, we have at least 4 cases which we believe have to be dealt with. And out of the 4, 3 involved Hong Kong people being murdered in Hong Kong, and 2 suspects. The suspects in 2 cases are actually hiding in Hong Kong, and another case involved a suspect who is hiding in overseas country. And also, another case also involved a Hong Kong person who has committed abduction case, an abduction case in Hong Kong, and still he is fleeing. So it's not just about victims in Hong Kong. In fact, there are 3 cases involving Hong Kong people being murdered, and yet because of the constraint of the existing laws, we can do nothing about it. And because of the fact that we have not been able to do anything about it, there have been cases involving persons who have committed very serious offenses in overseas jurisdictions, and they are still at large in Hong Kong. So are we going to allow this to continue so that they might be threatening the safety of Hong Kong people? Should we allow that to continue? So this is something that we have to deal with. Next, Ray Chan. All right, some say that if we do not allow this to be passed, then Hong Kong will become a criminal's haven or a fugitive's haven. All right, we have been negotiating with the mainland authorities for 20 years, and still we have not been able to come up with a long-term agreement. Whose fault is that? Who should take up the responsibility? We don't have the arrangement in place. So does that mean that Hong Kong is already a crime haven? And the Bureau Director said that this is not a long-term agreement. All right, the name is that it's not a long-term arrangement. But then you're talking about a long-term arrangement under which one-off cases can be dealt with. So I think compared to a long-term agreement, it's even worse. Third, the Security Bureau has not conducted any public consultation. You do not have to argue. You can, you should not be asking people to send emails to the Security Bureau. Precisely because of that, the security panel, before they have finished with the drafting of the legislation, we can hold public hearings so that for those who have concerns, they can come and express their views. And even Taiwanese people can also come and express their views here. So I'll be giving time to the Bureau Director to answer the questions because he has evaded the questions time again. Claudia Mo already asked him this question. All right, the origin of this is the Taiwan murder case. And then for this amendment, it's not just about resolving this particular case. I can understand that. But then the thing is, after a lot of work, in the end, if the Taiwan case cannot be resolved, this is not what we want to see. So some members have already asked you, all right, is Taiwan aware of this? So is the Taiwanese government aware of this amendment? Because there is this premise, that is the Republic of China will have to admit that is part of the People's Republic of China. So it has to admit that. And yet you have not answered this question. All right, the Bureau Director did say that, in amending Hong Kong's laws, there is no need for us to consult other jurisdictions. But then, as Claudia Mo said, have you told the Taiwanese authorities that this is the premise of the amendment? And if they are aware of that, I'm sure they are aware of that. So if they do this, do they also have to consider their people's views? And if there is a very strong repercussion from their community, then will this be counterproductive? So, well, all right, your ambitious is great. That is, you'd like to make use of this case so that you'd be able to plug the legal loophole and you'd like to improve the system. But then the fact that you're doing this, the premise is that the the Republic of China will have to admit that Taiwan or the Republic of China is part of the People's Republic of China. So given the ambition and given your determination, you might be making the case even more difficult. So have you considered the sentiments of the Taiwanese government, or are you saying that, they have taken the initiative to make this request, but then are they aware of this premise of the amendment? Bureau Director. Thank you, Chairman. With regard to Ray Chan's attempt to incite trouble, I find it really very sad because he doesn't want this to happen. Rather than wanting this to happen or wanting it to succeed, well, we are trying to amend Cap 503. We have never asked anybody to do this on a particular premise. We're just trying to amend the legislation so that we can open the door and then we can start the negotiation with another party. This is as simple as that. And discussing this case is not what Ray Chan was suggesting. So I find it really very sad. Apparently, well, you can just go back and be sad, whatever you want. Well, I'm trying to tell you that in terms of a consultation, we cannot do it for too long a time. That's because, number one, after the case, we have already conducted legal research. We have already taken time on that. I can choose not to do anything. I can just tell the bereaved family that under the laws of Hong Kong, nothing can be done about it. I can choose not to do anything at all, but then I've chosen to do it, and I'm grateful to the Department of Justice and their colleagues for working very hard to find out what can be done about it because I really want it to succeed so that we no longer have this loophole in our laws. I hope that we can work together toward this common objective. Chairman, I think he's distorting my views. I was trying to explore whether or not we can have alternative approach which is less controversial and still we will be able to resolve this case. Mr. YEUNG. Thank you, Chairman. Just now, the Bureau Director already made it clear. That is, we simply do not have this extradition arrangement with Taiwan. That's why some of the major cases cannot be dealt with. And now we have about 8 cases. And because of the Taiwan murder case, that's why there has been this public concern. And that's why they are trying to improve on the existing system. I think it's late already. All right, it's happened so long ago, and there are these major cases that have not been able to be dealt with, and I think it's better late than never. That's why I'm prepared to support the proposal to improve on the existing mechanism. All right, whatever the opposition camp says is no use because however strict the legislation is, however hard we try to put in place safeguards, it will still say no to it. So we will have to be pragmatic. So this has happened and we have to be positive. We try to push things forward. And I can see that this is a very stringent system. First, you will have to get an arrest warrant. You will also have to get the CE to issue the certificate, and then the court will look into this case before permission will be given. But then I can see that in triggering this mechanism, the requesting party would have to furnish evidence before the case can be considered. And the opposition camp is very worried that, for example, on the mainland, if there is this extradition arrangement, all right, in terms of the information that they're going to furnish, would it be misleading or would it be incomplete to such an extent that the suspect or the person under investigation will be treated unfairly? Well, very often such evidence will depend on how the evidence is furnished or adduced in court. And if the court is misled, and if the details are not complete, then there will be injustice done on the person involved. So are there any safeguards to deal with that? Bureau Director. Thank you, Mr. Yu, and thank you, Chairman. Well, we can look at overseas experience. For example, well, the media have been very concerned about some extradition trials involving fugitives. Well, the person in question has comprehensive rights to defend himself and to make representations to the court under Cap 503. Well, that was enacted 21 years ago at the time of the reunification, and the court has already dealt with different cases, and they are very experienced.
As to whether the information provided will be sufficient, first of all, the information laid down must be to the satisfaction of the court, because for Section 1063, it provides that the information layout must be sufficient to support the committal. And second, of course, the person in question can make representation based on different safeguards, and the person will also be legally represented, for example, at different stages by to be represented by the duty lawyer or legal aid counsel. So there are provisions that would ensure all the requirements are met, for example, double criminality principle, and also the person must not be prejudiced on account of race, origin, nationality, or political opinions of the person. And also, if the offense is punishable with death, there must be a reassurance that the punishment will not be meted out. And there is also sufficient avenues for the person to exercise his rights, such as application for habeas corpus and the right to appeal to the Court of Final Appeal. And we have the experience of handling similar cases. Dr. Fernando Zhang. Chairman. About the homicide case in Taiwan, I think we share the common sentiment that it is really disheartening, and we are angry why the perpetrator, after returning to Hong Kong, could go scot-free. So in relation to this case, I think it is the wish of all Hong Kong people that legislative amendments can be made as soon as possible so as to bring this perpetrator to justice. We would like to do justice, and justice should be seen to be done. If the perpetrator is not brought before the court, not to be tried, then justice cannot be seen to be done. However, in order to do that, we also need to conduct a trial that is up to international human rights standards in determining whether the suspect is guilty of the offense. In your proposal, the chief executive will be given the authority to decide whether such a surrender proceeding should be initiated, and it also covers not only the mainland but Hong Kong and Macau. And we know that the mainland's legal system cannot guarantee any court proceeding that will follow the international human rights standards. And for the 46 types of offenses covered in Cap 503, it is not just about serious offenses such as rape, arson, homicide. It is not the case, as alleged by the pro-establishment camp, that we are misleading the public and we are spreading fear. Now we have offenses similar, related to taxation matters, financial matters. Ai Weiwei, in fact, has been prosecuted on these grounds. And we also have offenses against the law relating to infringement of property rights, trademark, etc., fiscal matters, etc. These are totally unrelated to serious violent crimes such as rape and arson. As long as the mainland government instructs that certain person in Hong Kong be arrested, the chief executive can then decide to initiate the proceeding of the surrender of a fugitive offender. This is fact, Secretary. This is the consequence that will follow if the law is amended. We want the law to be amended expeditiously, but then you should not open the door so wide. You should only open the door to the extent that this case can be resolved, and whilst at the same time Hong Kong people will be confident that this door will not be too wide as to allow anyone to be surrendered anytime. Can't you limit the opening of the door to Taiwan? We understand that Taiwan has been following the international standards. Why can't you make the proposal specifically applicable to Taiwan only? Secretary, I think I've answered your question. For the homicide case in Taiwan, it exactly demonstrates that similar cases may occur outside Taiwan, and we must not ignore it, because this is exactly happening in reality. About the 46 offenses, they are set out in Cap 503 and have existed for a long time. I have not heard any questions about the 46 offenses so far. But of course, now I've heard some comments. Another point, you have your view on the mainland's legal system, but I think that this is your personal view. As I mentioned just now, other jurisdictions have signed SFO arrangements, extradition agreements with the mainland in Europe, with France, Spain, Portugal, etc. They have signed agreements with China, and of course they have also considered the human rights aspects. And yet they have signed extradition agreements with the mainland. And in exercising the agreements, we will do our best to safeguard human rights. Well, if that is the rationale, we should follow what other countries are doing. Well, they have democratic elections. Why don't we follow them? Mr. Paul Chair, I think the election year will is coming soon. And of course, this is a controversial topic close to the heart of members. And I think we're focusing on two trump cards, and that is one of sympathy, the other of fear. Let's see how these cards play out among the public. Well, I'd like to thank Dr. Priscilla Leung just now for explaining very clearly the safeguards, and I'd like to thank Mr. Wong Kok Kin for phrasing this mechanism as a case-by-case basis. That is to say, we negotiate on each and every case. And about the mechanism, I thank Mr. Jimmy for spending his time to explain in detail all the procedures available, including judicial review, habeas corpus, non-refoulement claims, including the appeal mechanism, all the way to the Court of Final Appeal. For each procedure, it would take 3 to 4, if not 8 to 10 years. So there are safeguards on human rights. And fourth point, we're only talking about the framework. Without the framework, there is nothing we can do. But with the framework, it's up to Taiwan to decide whether to go ahead with it. We don't need to remind them. In fact, for our laws, Cap 1 expressly provides that Taiwan is part of China. If Taiwan is not happy with this basis, then there is no negotiation at all, because all the agreements are formed on this basis. So you're not only deceiving Hong Kong people, but also Taiwanese people. In point number 5, it is indeed a loophole. It is a procedural flaw. We cannot do anything about it, because at the moment, the details will have to be disclosed in the public domain, and the fugitive will abscond for sure. Among the 46 countries, well, in fact, only 26 countries could apply this, not the rest of the countries. Well, for the 46 offenses, many of these offenses are computer crimes, and at the moment, we cannot do anything about it. In the future, if we set down such a framework, we can decide whether to proceed with any action. But at the moment, we can take no action at all. Another point. The human rights situation in China is really bad. What about the case of Ai Weiwei? If he comes to Hong Kong, must we surrender him? What offense has he committed apart from political matters? Whether he has committed the crime of tax evasion? But regardless of that, we should disregard the political character or background. Many people are concerned about the mainland's legal system. But I think, in fact, in the Philippines, things are even worse. Well, we have a long-term arrangement with the Philippines and also a case-based arrangement. What is good for the Philippines is good for the PRC. Of course, I've also come across a lot of horrifying cases in the mainland. For the cases that I personally handled over the past 20 years, since the resumption of sovereignty, the situation has remained the same. And if this is the same under our legal system, well, first of all, I'd like to urge the Secretary to consider revoking the agreement with the Philippines. Well, I just need to explain very clearly to the public that they must not be subject to the scaremongering tactic of the Pan-Democrats. Mr. Peter Shill, I'm not a member of this panel, but I've heard the issues raised by members, and in fact, I received phone calls from the public, and I'd like to express their views on their behalf about this case committed by a Hong Kong citizen in Taiwan. It isn't until now that Hong Kong citizens are aware of the problem. In fact, there is a security loophole, and it is not just about this case in Taiwan. In fact, at least 3 Hong Kong citizens have been murdered, and because of the SFO issues, these perpetrators cannot be surrendered to Hong Kong. Well, let's say if there is a rape or other crimes committed outside Hong Kong, and if there is no such SFO arrangement, the perpetrators could just go scot-free. So it is totally unjust and unfair for South Asians or people of any nationality now in Hong Kong. Well, maybe they are a murderer or rapist in their own countries, and there is clear evidence of that. But then, because of the lack of SFO arrangements, there is no way we can drive them out. I think this is just unfair. I think the focus of today's discussion is on Hong Kong and the mainland, as some members put it, but I think we should take a wider perspective. It's about Hong Kong and Hong Kong's relations around the world, because we are aiming to protect the public in Hong Kong. As for the public's concerns, the Security Bureau should explain in greater detail in future meetings. Mr. Charles Mok referred to the 46 offenses in the framework. Well, Secretary mentioned that in fact they have been put in place for a long time, and so far nobody has raised any question. And Mr. Charles Mok then talked about computer-related crimes. Say if I set up a company called the B5000, and then in the mainland or say in a third world country, there is already an existing company of the same company name, and then there is an application for me to be extradited to the jurisdiction for trial for breach of their IP laws. But in fact, another member already explained very carefully it's up to the court to decide whether the person should be surrendered. And in fact, it's not just Mrs. Carrie Lam who would be signing papers. In fact, we have numerous courts of laws in Hong Kong. The judge will be our gatekeeper. So that means our judges will be the gatekeeper. Well, ultimately, of course, the chief executive will be the gatekeeper. But what about the case cited just now, the title, the company name B5000?
One of the important conditions to be met is that the person involved, all right, if the conduct takes place in Hong Kong, then he has also committed an offense in Hong Kong. So there is this double criminality principle, and this offense is also one of the 46 offenses in the schedule. All right, if he furnishes incorrect information in his tax returns, but then if he furnished false information, or if he engaged an accountant who submitted fraudulent information in his tax returns, then so this will apply. All right, if the case happened in Hong Kong, if it's an offense, and if he can be sentenced to a year's jail, and if the case is also one of the crimes in the schedule, that is one of the 46 crimes in the schedule, then it would apply. Mr. Wu Chi-wei, well, many members of the public and many members, when it comes to the surrender of fugitive arrangement, I think a core issue is about what the Bureau Director has often emphasized, is about whether or not there will be fair trial for the person involved. So for the element of fair trial, so how should we interpret it as an idea? So what would constitute a fair trial, what would not constitute a fair trial, and also for the jurisdiction that you're going to surrender the fugitive to, whether or not they're going to have fair trials, and of course it's up to the interpretation of the Bureau Director. Would that be a condition? Would that be a defense for the fugitive concerned to raise? So should it be a factor under consideration? Because over the past 20 odd years, with regard to some jurisdictions, the reason why we have not been able to reach a comprehensive SFO arrangement is whether or not the suspect will be able to have fair trials in that jurisdiction. That's point number one. And number two, after that fugitive has been surrendered to the receiving party or the receiving jurisdiction, well, let's assume that the trial process, all right, he is already in the hands of the local government, and if it's treated unfairly, then what can the Hong Kong SAR government do? Does the Hong Kong SAR government have any power to deal with the situation so that the person will be able to have a fair trial? And also, are there any ways for you to ensure that by the time when he is transferred to that jurisdiction, he cannot be prosecuted under other laws or for other offenses? All right, if the local authorities say that, all right, instead of suing you for this offense, I'd like to sue you for other offenses as well, then with regard to the fugitive, can you rescue him, so to speak, so that he would only be subjected to the trial that has been the condition under which that he has been transferred or surrendered? Well, under Cap 503, there are certain restrictions, and many have to do with whether or not he'll be able to have a fair trial. Some guarantee will have to be made. That is, he cannot be tried in his absence, and he cannot be prosecuted because of his race, nationality, and so on and so forth. So that would also not be permitted. And when they make this request, the nature of the case must not involve these elements. So that's the safeguard too. And also, there should not be double jeopardy. In other words, if he has already been tried in one place for this offense, then he cannot be tried again in another for the same offense. And also, in the surrender arrangement or agreement, it will have to state very clearly as to what offense he has been prosecuted for. So he can only be tried for those offenses, and therefore they cannot add further offenses. So these are the safeguards. So our court will be looking at all these safeguards in hearing the case. Sorry, Chairman. In fact, my question is very simple. Yes, of course, I know that when you release the fugitive to that jurisdiction, of course, you will be acting in strict accordance to these safeguards and mechanism. But then what if it's not what actually happened? Then are there any things that you can do to help him or to rescue him, so to speak? All right, with 20 countries, we have already signed agreements during the past 20 years. And of course, they are not going to breach those agreements. And such agreements are open for all to see. And we are all aware of the terms. So when we sign such agreements with other jurisdictions, it's a very solemn agreement. And everybody will have to abide by these agreements, and we will also have to put in place safeguards to ensure that they will honor those promises. Okay, after Mr. Tony Chair has spoken, we'll deal with the motions, and for those moving the motions, please do come back in time. Mr. Tony Chair, all right, we have already signed MLA agreements with some 30 jurisdictions, and we have also signed SFO agreements with some 20 jurisdictions. So that's about the surrender of fugitives, and up till now, for so many years, it's been operating very smoothly, and yet within the one country mechanism, Taiwan, Macau, and the mainland have yet to have such an arrangement in place. All right, it's over 20 years since the reunification, and still we have not signed such an agreement with the mainland authorities. I can understand that, well, for Hong Kong, Macau, Taiwan, and the mainland, we do have different legal systems, and there are also different mechanisms in place. And as a result of that, we have not been able to reach an agreement with these jurisdictions. That's why in the light of the Taiwan murder case, we'd like to pass this amendment so that for one-off cases that can be dealt with under this proposal. So I think there are justifications for that, and we should support that. And of course, some people are bound to think that given the fact that Hong Kong and the mainland have different legal systems, and there are discrepancies and so on. But then when you look at the proposal made by the SAR government, I don't think we should politicize it. We should not demonize it either, because we know that Hong Kong practices the rule of law, and for this one-off case-based approach, in terms of legal protection and also human rights safeguards, the suspect will be given more protection rather than less. And when compared with other overseas jurisdictions where we have signed such agreements, I think there will be more safeguards rather than less. For example, they must not be surrendered for political offenses. It's not like somebody who might have said that the CE can just issue the certificate casually, because there are gatekeepers, because every step of the way the court will be acting as the gatekeeper. And some in the opposition camp in the past have emphasized that they have trust and faith in our judicial system and in our judges and so on. So how come on this occasion, apparently they do not have any faith or confidence in our judges? Well, Chairman, I have a question. In fact, it's very simple. In fact, looking back at so many years, well, on the mainland, according to some figures, I don't know if they are correct, please clarify. All right, there have been over 200 Hong Kong offenders or mainlanders who have been surrendered. All right, they've been extradited, and they've been surrendered to the mainland. But then on the contrary, well, somebody might have committed an offense on the mainland, but then in the past, Hong Kong has never, ever surrendered any one single fugitive to the mainland. All right. Many people view Hong Kong as a criminal's haven, because when they have committed offenses, they can always flee to Hong Kong. And also when it comes to serious criminal cases, even if there is no such extradition arrangement, but then for those who have committed serious crimes, if they are in Hong Kong, then are there any mechanisms that we can do something about it in order to prevent them from committing more serious crimes in Hong Kong? Bureau Director. Okay, where there are wanted persons on the mainland, well, the mainland authorities well, for Hong Kong people who have committed crimes in Hong Kong, and they might be extradited from the mainland and surrendered to Hong Kong, well, that's an administrative arrangement. And indeed, it's true that we have never surrendered any Hong Kong suspect or fugitive to the mainland authorities. That's true. Second, in dealing with any such arrangement, what we are trying to do is to apply the same standard to all jurisdictions so that CAP 503's requirements will apply to all jurisdictions. So I hope that you'd understand that. That's the problem that we are facing. Okay, for those who have requested to speak, they have all been given a chance to speak. So would you like to make an overall response, Bureau Director? Yes, let me succinctly highlight several points. First, for the Taiwan murder case, it has indeed highlighted the existing legal loopholes and problems. I can choose not to deal with it at all and then tell everybody that the existing law cannot deal with it. And I'm sure it would be an easier way out than adopting the current approach by explaining to you why I am submitting this proposal to you. But then I hope that you would agree with me that my conscience would not allow me to do that. That's why what I'm dealing with is to adopt a long-term arrangement to plug this legal loophole so that we'll be able to target at all jurisdictions, any jurisdiction in the world, there is a chance that this could happen again. That is, the Taiwan murder case could happen in anywhere in the world. And of course, we are dealing with the Taiwan murder case, but then if we just adopt a one-off approach, it will not be able to deal with similar cases happening in the future. And I'm applying the same standard. That is the same standard that is applicable under the FOO and also the MLAO. I'll ensure that everybody involved will be protected in terms of their human rights. That's precisely the responsibility of the SAR government. And under the amendment, I'll be ensuring that their human rights will be protected. And also, the courts in dealing with such cases, they are very experienced. Because CAP 503, the Fugitive Offenders Ordinance, has been in place for 20 years and the court has already tried such cases in the past. That's why I have full confidence in our courts that will be dealing with all these surrender requests under the FOO. And the most important point is, let's not forget that allowing these fugitives to flee back to Hong Kong or to stay in Hong Kong or to hide in Hong Kong will pose risk to the personal safety of our public. How can we allow a murderer or a sexual offender to stay next door so that they can live side by side with others in the same community? So I hope that you consider this seriously. I've approved 4 motions that are related to this, and in accordance, I'll deal with them in accordance with the order of receiving those motions. First is one moved by Ms. Claudia Mo. Ms. Mo, can you read out the text that this panel is against the amendment to the MLAO and the FOO so that it can be extended to the PRC, because we have no confidence in the judicial system in Beijing, and we have no trust in that either, and therefore we are concerned that it might become a tool to oppress political dissidents, and therefore we should deal with we should go for the easier problem first, and we should deal with the amendment concerning Taiwan. Okay, so are you claiming a division? Yes, so we'll have to ring the bell for 5 minutes. We have a quorum already, so just press the button and then we'll put it to the vote.
好，嗱，我見到嗰啲咧，
All right, I can see that all those who are present have already voted, so the result will be displayed. 28 present, 10 for, 17 against. the motion is negatived. Next.
就係阿楊岳橋。
Mr. Alvin YEUNG, to expeditiously deal with the surrender of fugitives' request in relation to homicide case in Taiwan, to do justice to the victim and the family, this panel urges that the Security Bureau, when amending the FOO and MLAO, expressly provide that the amendment only applies to Taiwan to avoid unnecessary controversy arising from discussion with other jurisdictions and delay in surrendering the fugitive. Please vote.
所有人都
Has everyone voted? Please cancel Mr. Lam Ting's vote. Wrong seat, sorry. Can this be done? Can his vote be cancelled? All right, Mr. Lam Ting's vote must be cancelled first. Let's make things clear to avoid misunderstanding. Voting result. 30 present, 12 for, 17 against. This motion is negatived. Mr. Dennis Kwok, thank you, Chairman, to expeditiously handle the SFO request in relation to the homicide case in Taiwan, to do justice to the victim and the family. The panel urges the Security Bureau to introduce sunset clause in amending the FOO and MLAO to stipulate a time limit for the amendment. Please get ready to vote. You can now press the button. Has everyone voted? Voting result will be displayed. 30 present, 12 for, 17 against. The motion is negatived. Last motion moved by Mr. Holden Chow, please. As in the beginning of last year, Hong Kong female citizen was murdered by her boyfriend in Taiwan. The Taiwan authority numerously made surrender requests because of lack of SFO arrangement between Hong Kong and Taiwan. The perpetrator could not be surrendered to Taiwan for trial, and no justice is served for the victim and the family members. And it also expresses the loophole in the MLA system. Hong Kong can become a crime haven. This panel therefore supports the Security Bureau in amending the MLAO and FOO so that we have a comprehensive cooperation mechanism, and because there is a chance that the perpetrator may abscond, the panel urges the Bureau to submit the proposal as soon as possible for scrutiny by LegCo. Members, please proceed to vote. Mr. Kwok, are you going to vote? Voting result. 38 present, 17 for, 12 against. The motion is passed. Secretary. Mr. Ray Chan, I made a suggestion. I hope that before this bill is tabled, I hope the panel could conduct a public hearing. Yes, I will deal with that as well. Order, please. Because Mr. Alvin YEUNG and Mr. Dennis Kwok already jointly wrote me a letter urging me to hold a joint meeting with the AJLS panel on this matter so that the judiciary, the Bar Association, Law Society can also take part in the meeting. I understand from the Secretary that on the part of the administration, the public will also be consulted. I understand that in scrutinizing the bill, public hearings will definitely be held. I therefore don't find it necessary that this panel should call for a special meeting and invite views from the public. But in relation to Mr. YEUNG and Mr. Chan's suggestion, after the meeting, I will talk to Dr. Priscilla Leung, chair of the AJLS panel, about it. But I don't think for this panel there is a need to hold a special meeting to invite deputations to give views, particularly on this matter. Mr. Wong Kok Kin. I think the murder suspects, as we all know, cannot be detained for much longer. So there is an urgency in this matter. If we want justice to be served, if we consider the matter from the victim's family's perspective, I don't think we should put up excuses to delay the scrutiny of this bill, because definitely at the Bills Committee public hearing will be held. There is no need to hold another meeting. Dr. Fernando Cheung. There is a key difference here. After the government has tabled the bill, and if the public hearing is held by the Bills Committee, the difference is that we have a long title, the short title, and the bill as a draft of the legislation. And it will be impossible for us to make any change that falls outside the scope of the long title of the bill. If the long title provides that all the jurisdictions involved would be any place outside Hong Kong, Macau, and the mainland, and if we are only focusing on Taiwan, by then it will be impossible for us to make any change because of this issue. So I do think the public hearing should be held before the bill is tabled. I should not answer on behalf of the administration, but as I understand, the administration has a mechanism to invite the stakeholders to give their views. Am I right, Secretary? Yes. We have announced this proposal and we welcome views from the public. But this is the Council. We have the duty to provide a venue for deputations in the public to give views directly to the administration. And it is also important to seek views from the judiciary and the legal professional bodies. Mr. Eddie Ju. I don't think Chairman, your good self, would think that by providing an email for members of the public to write in, it will be the same as holding a public hearing in this council. It is not replaceable. I don't think this is what you mean. I've made my decision, but after the meeting, I will discuss with the AJLS panel on your behalf. If there is no other question, then meeting is adjourned.